everybody. Director McLaughlin,
Here.
Director Bernstein,
Present.
Director Crawley,
Present.
Director Jones,
Here.
and Director Solano is absent. Thank you. Director McLaughlin, did you want to do the start the Pledge of Allegiance?
Certainly. Please join me in the pledge of the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you. With that, I will turn it over to Stephen Miller to introduce our purpose for being here today.
Thanks. So just very briefly, I appreciate your attendance here. You are all, as directors of the board, obligated by law to attend a 2-hour sexual harassment prevention training. And I'm very pleased that you've asked my partner, Jennifer Martinez, to train you all in accordance with the statutory obligation. So thanks for taking this seriously and attending as required. Jennifer is not only a partner in our employment and labor group advising the district and other entities, but she is our Chief Diversity, Equity, and Inclusion Officer. Our firm has a big commitment to those virtues, and Jennifer is spearheading and leading our efforts in that regard. She's provided this training to numerous employers and like the district. And with that, unless anybody has any questions for me, I was not planning on interfering with Jennifer's work and may actually not even attend. I have to get trained like the rest of you, but I already have gotten my 2 hours. So I don't think I need to charge the district for my participating in this session. So you're in good hands with Jennifer, and with that, I will pass on to her.
Thank you.
Great, thank you, Steve. And actually, Michelle, if you could, I just got a message saying that I am prohibited from screen sharing. So if you could make the adjustment there, I'll share my slide deck.
Okay, I think you should be good now if you want to give it a shot.
Okay, great, here we go. All right, so, and let me make sure I can still see all of you. Okay. This is, as Steve mentioned, your mandatory harassment prevention and abusive conduct in the workplace training. Some quick kind of ground rules before we get started. With this small of a group, obviously you don't have to sign in. Michelle will be making note of attendance. I intend to be as engaging as possible, but promise you don't want to have to do this twice. So make sure Michelle's got a record of your here. Keep in mind that today's training is not legal advice about specific situations. We'll be talking about legal issues. We'll be talking about fact patterns, some cases. But if you have questions about specific scenarios, I just ask that you save those separately from today's training so we can keep that line clear today. Obviously, some content could be perceived as offensive that we'll talk about today. We're going to be talking about harassment, discrimination, those kind of issues. Despite any attempts at humor on my part, of course, these are very serious topics and we should treat them as such. Please do feel free to ask questions. I like when this training is interactive. There may be some points where I call on folks if I don't get volunteers. So just heads up on there. Feel free to also submit any questions in the chat function, and I will try to keep an eye on that periodically. Keep in mind that I've got a note there saying the session is not recorded. I learned after submitting the slide deck that that is the case. All the more reason not to bring up any specific scenarios. I would ask that if you've got a question about some specific scenario, that you just not use anyone's name. Just go ahead and anonymize it or make up a name when you're asking your question. This is what we're going to cover today. We'll talk about what harassment is and what the legal elements of harassment claims are. We'll talk about who can be a victim of harassment and who can be held liable and what it means to be held liable for harassment. We'll also cover California's anti-abusive conduct and workplace bullying statute and how it differs from harassment. We'll address what your obligations are given your positions with the district for monitoring the workplace for harassment and what to do when harassment either is brought to your attention through your own observation or through a complaint. Our last legal section, we'll talk about retaliation claims and how those are often the most risky area of this type of law. And then we'll close out talking a little bit about microaggressions, unconscious bias, and how these cases play out in the real world. So why are we here specifically? The easy answer is AB 1825. It's a law that's about 16, 17 years old now. It's the law that specifically mandates any supervisory employee have 2 hours of anti-harassment training every 2 years. But I submit to you that we would still do this training even if it weren't legally required. And that's for a couple specific reasons. The first one is the prevalence of sexual harassment in particular. These numbers are from a 2018 study conducted by the EEOC, in which 60% of women who responded to the study reported that they still experienced in 2018 sexual attention, crude conduct, or sexist comments in the workplace, and a full fifth of men reported the same. So despite the fact that the training requirement is nearly 2 decades old, certainly is not a problem that's been eradicated from the workplace by any means. Another reason I think we do this training, even if it weren't legally required, is the form that harassment takes in the year 2021. We don't really get kind of the horrific fact patterns, the Mad Men style fact patterns, for those of you familiar with that television show. Instead, what's much more common is covert harassment, right? The Michael Scott type of harassment, a supervisor that is well-intentioned, that likes his employees, that wants to do the right thing, but maybe has a different conception of social boundaries than everyone else, or isn't that great at reading social cues and gets themselves into some trouble. So with that type of harassment, much more difficult to recognize when you're crossing a line, right? All the more reason for this training to help us put some lines with some more definition there. Next reason I think we do this training even without the legal requirement is technology. And we'll talk a little bit about that this afternoon. It's fundamentally changed the way that employment cases are litigated. It used to be that evidence in employment cases was really based on witness testimony exclusively, right? And that meant that it was dependent on individuals' ability to recall their memory, to recall the kind of proverbial water cooler conversation. Well, now with technology, with email, with Slack messages or other chat functions, text messages, we potentially can capture every single communication between two people. And like I said, fundamentally change these cases, the way these cases are litigated, made them a lot more risky and a lot more difficult to explain after the fact. Lastly, and probably most significantly, I think we do this training even without the legal requirements because of the costs at issue in harassment and discrimination suits, especially sexual harassment cases. And there's both individual and company concerns. And when I say company, I mean the employer. For the individual, if you are in a supervisory position, you can be named as an individual defendant in a harassment suit. That means there's potential economic costs to you, right? If there's a judgment against you, your assets can be used to satisfy that judgment. Even if you win the case, it can cost a lot in attorney's fees to get to that win. Certainly there are emotional costs. Harassment lawsuits are public knowledge. Court records are public documents. You may have to explain to your significant other, your spouse, your family, your friends, people at church, any other person that you've been accused of these horrible things. You have to sit for a deposition. You have to spend a lot of time with your attorney going over discovery responses. It's certainly not an emotionless process. And then there's career costs to the individual, right? We'll see when we cover hostile work environment harassment that the higher up in an organization that an individual is, the more severity is attached to their actions when they are accused of harassment. So if you have a record of harassment complaints against you, it's going to be significantly more difficult for you to move up that corporate ladder. For the employer, there's similar concerns, right? The economic concern is obvious. Again, if there's a judgment or like I said, even to get to a win can cost a lot in attorney's fees. And then there's a morale and a PR concern, right? Like I said, harassment lawsuits are public documents, and media love stories of harassment, especially government employees behaving badly. The more salacious, the better. And you can almost guarantee that in a particularly salacious case, it's going to be front page news. We don't want to become obviously known as somewhere, a workplace that tolerates discrimination or harassment. Will be significantly more difficult for us to recruit and retain quality employees if that becomes the reputation. So what kind of costs are we talking about specifically here? Bunch of verdict examples. I like to start this training out in sort of a shock and awe effort, right? And you'll see with these case examples, there's really three big factors that cause jury awards to skyrocket in this area. First case I want to cover, 1994. This was a law firm here in the Bay Area. I include it because I think people expect lawyers to get the law right. Certainly not an obvious or safe assumption all the time. A legal secretary accused her supervising attorney of lunging at her chest, pouring M&Ms down her breast pocket, and grabbing at her hips. In 1994 dollars, the jury gave her about $7 million. That included $225,000 in punitive damages against the individual harasser, right? That's the amount of money that the individual harasser was on the hook for. You've probably heard that phrase punitive damages before. That's the amount of damages that the jury just gets to make up. It's not tied to back wages. It's not tied to front wages, medical costs. It's simply the number that the jury decides is necessary to prevent and punish this type of conduct. Next case example, 2007, a harassment claim was filed against Isaiah Thomas in Madison Square Garden, and the plaintiff was fired within a month after complaining, despite being employed successfully for several years. This is the first element that causes jury awards to skyrocket. Any type of retaliation facts in a case. Jury gave her $11.5 million. Next case example, this was a tech company here in the Bay Area. 51-year-old employee claimed her supervisor made repeated comments about her breasts, his penis, and his sexual fantasies. She was also fired shortly after complaining. That's the second factor that causes our jury awards to skyrocket. Any type of sexual content. Not only do jurors pay more attention when a case involves sexual content like that, they're much more likely to see that type of behavior, those comments, conduct, inappropriate in the workplace, and it causes them to give greater damages to the plaintiff. So jury gave her $10.5 million. 2012, this was at a hospital here in the Bay Area. Physician's assistant claimed doctors asked her for sex, had explicit sexual discussions around her. One doctor intentionally stuck her with a needle, and when she reported to her supervisor laughed at her and fired her. So here we kind of have the trifecta of factors. But the third factor I want to highlight in particular is any type of physical touching. Here it was especially egregious, right? The intentional sticking with the needle. But anytime you've got physical conduct between the accused harasser and the victim, again, much like with the sexual content, the jury's going to buy that that's not no defense for that in the workplace, going to make them award a higher verdict. Jury gave her $168 million, largest single plaintiff verdict in an employment case in the history of the country. Of that 168 million, 125 million was punitive damages. That was the number that the jury got to make up, right? I have this case not just because it's a historic verdict in this area of law, but also because I know this plaintiff's attorney. Our firm litigates against him very regularly. I think we've got maybe 10 open cases against his firm right now. And I'm not just saying this, I am biased, of course, but I promise it's true. He's not a very good lawyer. He doesn't quite know what he's doing. He gets the rules wrong. And still, someone who's not a great lawyer, lucked into the largest single plaintiff verdict in the history of the country because of the facts, right? The facts are bad enough that he knew he had a winner here in front of the jury, and the jury certainly gave him those winning numbers. Last case I want to mention, it's not a harassment case. This was a gender pay equity case. It was at a pharmaceutical company here in the Bay Area, and it's the largest verdict ever in a gender discrimination case. Like I said, there weren't harassment claims, but this class of female pharmaceutical representatives sued alleging that they were paid less than their male counterparts, despite having similar experience, similar performance, et cetera. And as evidence of gender-based bias on the part of management, they presented evidence of something called microaggressions. That's the first time we saw that word in the case law, microaggressions. And I'll cover, like I said, at the end, what microaggressions are, how they come up in the workplace. But essentially, they presented evidence of, small little comments here and there by higher level management directed at women that men didn't face. So they presented evidence that women were regularly asked about their plans for having children and getting married, and that men were not asked those questions. They were discouraged from applying for management jobs if they planned to have children or get married. They were teased about going to the restroom in groups or punished for using the restroom more frequently. And the jury bought it. They saw all this evidence of these little comments. When you look at it, kind of an accumulation, evidence, gender-based bias on the part of management. The jury gave this class of women $250 million in this gender pay equity case. So now that I've scared you, I want you to pay attention, especially to this slide, probably the most important slide in our session today. That's the importance of early intervention. This early intervention principle will come up quite a bit in our training this afternoon. But essentially, when a lawsuit lands on my desk, it's never because the harassment happens last week or last month or even 2 months ago. It happens way, way far in the past, right? There's a big problem now. If there's a lawsuit now, at some point in the past, there was a very small and fixable problem. And the point of this training is to hopefully encourage you to intervene at that small and fixable stage so that things don't snowball. And you'll see that the earlier you intervene, the easier it is to correct and prevent problematic behavior from happening, okay? So before we dive in, usually like to give a quick illustration here of what not to do.
This is huge. That's what she said.
Let's do it. Let's get ugly. Let's get real.
Okay. If I have to do this, based on stereotypes that are totally untrue, that I do not agree with, you would maybe not be a very good driver.
Oh, man, am I a woman?
Listen, you're cute. There's no getting around it. So, I don't know if you like country music, but I was thinking maybe one of these days we could drive out to a field, crank up some tunes, smoke a few back and nudos, maybe even toss a disc around. But wait, ude, uye, they ampe.
Yes.
Dwight tried to kiss me.
What?
And I didn't tell anyone because I'm not really sure how I feel about it.
That is not true. Redact it. Redact it.
Well, I'm not actually making a formal complaint. I just really think we should talk about it.
Michael, this must be obvious how wrong this is.
Oh, the Antichrist.
Okay, you can't. Ow! Look, you cannot push religion.
Oh, but I can push drugs in here. Is that what you're saying? Well, you have to pick one or the other. Your choice.
I'll go. No, sweet cheeks. We need somebody who's actually made a sale.
Am I hot right now?
Why would I or anyone else think that you're hot right now?
I need 2 men on this. That's what she said. No time. What she did. No time, guys.
I never touch a pregnant woman.
Yep.
Sold for $300 to me. The hell's that?
It's the only gavel I could find.
It squeaks when you bang it. That's what she said.
Who saw Dwight do this?
Okay, really?
Would you consider this a terrorist incident?
I felt terrorized. Come on.
Michael's got a few tricks for Valentine's Day. He found a place where you can get 12 plastic roses for $10 And he's got a great line. Me so thorny.
There's that ass.
Hey, hey, yeah.
Yeah. Oh, don't take it away.
Oh,
All right, so every employment lawyer's favorite TV show, The Office, believe it or not, a little bit more true to reality than you might expect. As I said, that a lot of the cases that we get now are the Michael Scott type of supervisors, right? It's a little comment here and there that when you look at it in a big picture like this, really paints a problematic workplace, but maybe on its own is not something that people react to. Next quick exercise before we get into the law. And I like to take the temperature of the room whenever I do this training. We're going to see a bunch of scenarios that appear on the screen one by one. Just raise your hand in your screen if you think what appears constitutes sexual harassment, okay? And we'll start with what's hopefully an easy one. Male supervisor gives his assistant a pat on the butt. Raise your hand if you think sexual harassment. If your hand's not up, let's talk afterwards, all right? Little bit different here. Male NFL coach pats the quarterback on the butt. Who thinks sexual harassment? Not as many hands. It's his boss, right? They're in his workplace, but maybe we think there's some factors that make things different. Okay. Next one. Female construction worker with a short haircut is called butch by her coworkers, both male and female. Who thinks sexual harassment? Anyone think it matters legally that both men and women are participating in the harassment? It's not. An employee tells a blonde joke. Who thinks sexual harassment? Let me ask you this. Do you ever hear blonde jokes where the blonde is a man? No, it's always a blonde woman, right? Supervisor asked to discuss a promotion with an employee in a hotel room. Who thinks sexual harassment? Hopefully Harvey Weinstein has taught us this lesson. Little bit different. Supervisor asked to discuss a promotion with an employee over dinner. Who thinks sexual harassment? Let's go out on Friday night, little candlelit booth, and discuss whether I'm going to give you a raise, right? Maybe the words I'm using are a bit exaggerated, but the implication is there no matter how it's framed, right? A single employee seeks love advice from a married coworker. Who thinks sexual harassment? Maybe depends on what's said and who's around to hear it. An employee has a loud personal phone conversation about their date last night where everyone can hear. Who thinks sexual harassment? Again, probably depends on what's said, how loud they are. Anyone think it matters legally that the person on the phone is not physically in the workspace? It does not. An employee compliments a coworker on their outfit. Who thinks sexual harassment? Again, this could go either way, right? Kind of depends on how the compliment is said and what kind of compliment is made. There's a big difference between saying, oh my gosh, that's a really cute skirt, and ooh, cute skirt. I can't wink, so you'll have to forgive me the eyebrow movement here. Last one, an employee hangs a Sports Illustrated swimsuit calendar in their workspace. Who thinks sexual harassment? Right, even though no words are exchanged or people aren't interacting with each other, the calendar enough is certainly can constitute sexual harassment. The point of this exercise is simply to show that reasonable people can differ on where these lines are, right? We didn't all have our hands up for every single situation. If some of the situations depended on what was said, who was there to witness it, how loud it was, how it was said, and it's those factors that create this gray area that eventually can lead to potential lawsuits and disputes. All right, let's dive into the actual legal substance here. These are the sources of the anti-discrimination and harassment protections we're going to be talking about today. At the federal level, you have Title VII of the Civil Rights Act. That's your oldest, really comprehensive statute at the federal level. Includes anti-discrimination and harassment provisions on a number of protected categories. You also have the Age Discrimination and Employment Act, the ADEA, and that provides age-related protection to employees aged 40 and over. Separately, you've got the Americans with Disabilities Act. Most people understand that law as the one that obligates employers to provide accommodations for employees with disabilities, but there are also some anti-harassment and anti-discrimination provisions in that law as well. And then lastly, you have the Equal Pay Act, which is specifically related to gender-based disparities in pay. At the state level, you have the Fair Employment and Housing Act. That's your most comprehensive statute. It essentially encompasses all 4 of the federal acts into one single law. It is by far the most common law that plaintiffs sue under in California. Separately, you've got the Pregnancy Disability Leave Act, primarily intended to give employees who are pregnant or have childbirth or breastfeeding any time off for disabling conditions. But that law also has some anti-discrimination and harassment provisions. And then California cities have a number of local ordinances that also provide protections against discrimination and harassment. None that I'm aware of down in Menlo Park, but San Francisco, for example, has a height and weight proportionality ordinance. So you can't discriminate against or harass anyone in San Francisco based on how their height and their weight are related to each other. This is the legal definition of discrimination. It's from the Fair Employment and Housing Act. It's to refuse to hire or employ a person, or to bar, discharge a person from employment, or to discriminate against a person in compensation or in terms, conditions, or privileges of employment based upon a protected category. 2 things I want to call out in this definition here. The first is that first underlined phrase, terms, conditions, or privileges of employment. So discrimination isn't just about who gets hired and who doesn't, or who gets fired and who doesn't, or gets a promotion. Really, it's about any benefit or term associated with employment. So there's a famous Supreme Court case, for example, from the 80s that involved a stockbroker firm in New York. And there, the term, condition, or privilege of employment at issue was where a woman stockbroker was assigned an office. And that was enough of a term, condition, or privilege of employment in that particular workspace to be the subject of a discrimination lawsuit. Second thing I want to point out in this definition, and that's that last underlined phrase, based on a protected category. Really crucial in this definition. Without that underlined phrase, this definition might be read to say you can't treat employees differently at all. And that's not what the law intends or requires, right? Perfectly fine to treat employees differently based on legitimate things. One person sells more things than another, they get a larger bonus. It's when those employment decisions are based on a protected category that they're potentially unlawful. This is the legal definition of harassment, also from the Fair Employment and Housing Act. It's conduct or employment decisions based on a worker's protected category that unreasonably interfere with an employee's equal employment opportunities or create an intimidating, hostile, or offensive working environment. So again, you have the requirement that it be based on a protected category. I think a lot of times you hear employees say, my supervisor is harassing me, and they're sort of using harass colloquially, right? They're saying that my supervisor's bothering me, they're micromanaging me. Well, that's not illegal. It's when that treatment is based on a protected category that it becomes unlawful harassment potentially. One other thing I want to call out in this definition, and that's that it includes 2 different types of harassment. The first is what we call quid pro quo or economic harassment, and the second is hostile work environment harassment. We're going to cover both types in our training today. Really important, though, to know the difference between the 2 because different types of liability attaches. Both of those definitions use the phrase protected categories. What are those categories? Race, and this includes everyone. So it's not just minority races that are protected under the law. White employees also fall under this category. Color is a separately protected category from race and intended to acknowledge that even within the same racial group, there can be biases based on light and dark skin. National origin or ancestry is where an employee is from, as well as where their ancestors or their family is from. It encompasses things like accents as well. And something I always like to mention in this training is think about ways that kind of our everyday language sometimes incorporates these biases. So I always like to point out the word gyp, which I'm sure you've all heard. It kind of means to scam or to cheat. It actually comes from a derogatory reference to Roma or Gypsy people. So now that you know, maybe we don't use that word in the workplace anymore at all. Alienage or citizenship, just slightly different than national origin or ancestry, and really only comes up in the hiring context. It's why when we're interviewing someone, we never ask if they're a citizen of the US, we only ask if they're eligible to work here. You can work in the United States without being a citizen. Sex, and this includes pregnancy, it encompasses biological differences as well as gender-based stereotypes. Age, and again, this protection is only for employees aged 40 and over. There's no protection on the basis of age for anyone under the age of 40. And again, think about subtle ways that age-related comments can creep into your everyday language. I do a ton of work with tech companies and Silicon Valley companies. You guys are down in the Valley. I kid you not, maybe twice, 3 times a year, I get a call from a client because there's been a complaint made. Some manager used the phrase youthful energy or something similar, right? They're launching a new product. They say, let's shake up the sales team and get some youthful energy here. Well, that potentially indicates a bias in hiring on the basis of age. Physical or mental disability. There are several disabilities that are specifically named in the law, but keep in mind too that for something like a mental disability, that's not necessarily going to be obvious when you're talking to someone, right? And again, I bring up subtle ways that our language sometimes incorporates these categories. So I work in a law firm, bunch of lawyers, type A personalities. I hear the phrase OCD used a lot to mean I'm particular about something, right? Make sure you file these papers this way. I'm very OCD about it. And I don't think that anyone who says that necessarily is disclosing that they've got obsessive compulsive disorder. It's just become this shorthand way to say I'm particular. Well, it does reference ultimately an actual disabling condition. So you never know if you say that casually to someone, you could be talking to someone with that condition and you don't know, and now you've just made light of it, right? Same thing with words like crazy, or hopefully no one is still using the word retarded, but those types of words also run afoul of this category potentially. Religion, this includes the major traditional religions, Islam, Judaism, Christianity, Buddhism, etc. Also includes non-traditional religions. So the standard is simply that it be a belief system that is recognized for the individual, not an isolated teaching, which occupies a place of importance in someone's life equal to that of traditionally recognized religions. So courts that have interpreted this category have held that atheism is protected under the religion category, but something like veganism is not protected. Military service, this is an activity-based category and encompasses all types of connections to military service, right? Veterans, National Guard or weekend warriors, people that are associated with military families or maybe our military spouse. Exercising leave rights under the Family Medical Leave Act, another activity-based category. So the moment that someone inquires about using leave rights or actually uses leave rights, it's that activity that places them in a protected category. And then lastly, genetic information. And I have this one up there because it's included in the statute, but really only comes up in large-scale benefits litigation. So we won't really be touching on it today. California law protects a number of those same categories. The request for statutory leaves is a little bit broader and encompasses California specific leaves. And then California law goes beyond federal law and protects a number of additional protected categories. Sexual orientation is one. This was actually changed just last year at the Supreme Court level. So sexual orientation is protected under the federal categories as well. But this category, again, includes everyone. So straight employees are covered under this category. It's not just LGBTQ employees that are protected. Gender identity and gender expression, two relatively new categories. I'm actually going to put a pin in those and we'll cover them on the next slide. Medical condition, a little bit broader than disability and intended to encompass a lot more temporary conditions. Marital status, and again, this includes everyone, married, single, divorced, widowed, etc. Think about subtle ways that this might come up in the workplace. So for example, you need to assign some late night or some weekend work, and maybe subconsciously or consciously, you assign it to someone on your team that is unmarried and without any kids, thinking that they can best accommodate the late night and the weekend work. Well, now you've just made a job assignment based on a protected category, right? Potentially unlawful. And then lastly, local laws. I will mention that my favorite in California is the city of Santa Cruz has an anti-lookism ordinance. So you can't discriminate against or harass anyone in Santa Cruz based on how they look at all. Tattoos, piercings, dyed hair, not a valid basis for employment decisions. Fascinating for me in my world. Key takeaway here is that everyone falls into multiple protected categories, okay? Other than the age category, it's in every category, not just the minority group is protected, the majority group receives the protection as well, okay? So I said we'd put a pin in gender identity and gender expression and come back to those. Those were added as protected categories to the Fair Employment and Housing Act within the past 5 years. And when the legislature added those categories, they required us to cover some definitional terms in this particular training. So I know that these terms have a social definition, they have an academic definition, not intending to erase those. These are just the terms as they are defined in the Fair Employment and Housing Act. Gender is the sex that's assigned to someone at birth. It's not a decision that an individual makes. It's usually something that's assigned by a doctor in a hospital at or around the time of birth. Gender identity is someone's internal understanding of their own gender or their identification with a particular gender. It can be male, it can be female, it can be somewhere between the two or a combination. It can be neither male nor female, and it can also be different from the sex that was assigned to them at birth. Gender expression is a different thing than gender identity, and keep in mind that both gender identity and gender expression are different and independent from sexual orientation as well. But gender expression is sort of the flip side of gender identity. It's the way that someone presents their gender to the outside world. It includes things like gender-related appearance and behavior. And keep in mind that gender expression, while certainly an individual expression, also has a social element, right? Rewind 100 years ago, it's 1921. If a woman wore pants to a job or on a date or just out in public, she might be sending a very specific message about her own gender identity or gender expression. In 2021, a woman who wears pants to work or on a date or in public is saying exactly zero about any of those things, right? And then lastly, transgender under the law is simply a general term that refers to someone whose gender identity differs than the sex that was assigned to them at birth. How do these things come up in the workplace? Well, obviously, we want to refrain from any gossip, rumors, speculation, any discussion about someone's gender identity or their sexual orientation. You would be surprised how frequently I get calls from clients about, I call it the case of the new hot employee. And it usually develops that, you know, someone's been hired that's unnaturally attractive. And there's discussion amongst their coworkers about what team they play for. And because everyone's interested. Not an appropriate topic of workplace discussion. If employees have a preferred name or a preferred pronoun, that's what we're going to honor. You may remember a couple years ago, Facebook rolled out, I believe it was something like 73 different gender options for Facebook profiles. And there was a big kind of media to do about, you know, are there 70 different genders? Is this something we should allow as a society? You are perfectly welcome to have that debate with your family and friends outside of work. At work, if someone has a preferred pronoun, even if it's a pronoun that you personally think is different than their gender identity or gender expression, your opinion doesn't really matter here, okay? We're gonna honor the name and the pronoun that they prefer to go by. If you do have any employees that are transitioning, you just wanna make sure you get HR involved as early as possible to ensure legal access to facilities, to accommodate dress code issues, and most importantly, to help ensure respectful, proper communications amongst coworkers about the transition process. And then lastly, you want to be aware of some common microaggressions in this area, which, like I said, I'll cover at the end of our session here. Two last things on protected categories. Both federal and state law protect not just actual membership in a protected category, but perceived membership. And this type of protection is sort of cyclical with current events. So in the 80s, for example, in the height of the HIV and AIDS epidemic, there was an uptick in cases with employers who fired employees who experienced rapid weight loss. And they fired those employees because they were scared that they had HIV or AIDS and they panicked, right? Those employees sued for wrongful termination, for discrimination. And during the course of that litigation, those employees disclosed, my rapid weight loss was due to something else. I, in fact, do not have HIV or AIDS and have never had it. And once that disclosure was made, those employers thought that they won those cases. They said, well, we got you. If you've never had HIV or AIDS, I can't have fired you because of your HIV or AIDS status. And courts didn't buy that. They said at the time, you believed and you treated them as if they belonged in this category. That's what's legally significant. Kind of a related principle, both federal and state law also protect employees who are associated with a member of a protected category. These types of cases don't really come up that frequently, but the origins of this associational protection are kind of instructive. So this protection came up, cases in the 60s and 70s, largely in the South. And the common fact pattern was a white male employee who was employed successfully for several years, raised every year, positive performance reviews, and then he finally brings his Black spouse to the company Christmas party and all of a sudden is fired. Those employees sued and the employers defended themselves by saying, well, wait a minute, we didn't fire you because of your race, we fired you because of your wife's race. And courts didn't buy that even back then. They said, you're still making an employment decision based on a protected category, even if it's the protected category of someone else, and that's still going to be considered unlawful. Let me pause here. Questions on definitions and protected categories? No? All right. Oh, yes, I'm sorry. Director Kiraly.
Thanks, Jennifer. This is so informative. So this is, would you say this is primarily for the employer-employee relationship? Because if you look at board conduct of members among each other or among other elected officials, it's not quite the same, but I guess the laws would protect in the same way, or I don't know. I mean, I would think so, but it's not an employer-employee relationship.
That's a good question. Can I actually ask you to put a pin in that? We'll cover that on a couple.
Sure. Slides. Okay, thank you.
Yep, absolutely. Okay, under the federal and the state laws that we saw.
Chuck had a question.
Oh, I'm sorry, I missed the.
Yeah, I'm sorry, I was on mute also. I have a quick question. I want to ask how this fits with benefits, for example. I mean, I know that we wouldn't pay a married person more than a single person in terms of their compensation. But if we give them benefits that are greater, isn't that discrimination based on marital status?
So good question. There, it's a bit of a technical lawyer answer. The district is simply providing an insurance package, and the insurer has their own policies about what benefits are available for costs. Now, I think the other response too is that married couples who use the spouse benefit also end up paying more. So there's a balance that's associated there. It's not like married and single people are provided or are charged the same, but provided different benefits.
But if I, as an employer, chose to hire a single person because it would cost me less, I would be guilty of discrimination, right?
Yes, absolutely.
Doesn't seem quite fair, but.
So both federal and state law, they not only prohibit harassment, but they require employers to take all reasonable steps to prevent harassment from occurring. So courts have interpreted this obligation as a proactive obligation, okay? We're not allowed to simply sit back, wait for harassment to happen, and then address it when it does. employers have an affirmative obligation to prevent harassment from happening in the first place. Really important, especially when we talk about the obligation to monitor and report harassing incidents. Okay, who can be liable for harassment? And remember, being liable means your name can appear as an individual defendant on a lawsuit. The individual harasser can be held liable, especially if they're a supervisor or in a position of authority, like any of you as board members. The employer can be held liable for harassment when the harassment is quid pro quo. And like I said, we'll talk about that in a second. When the harassment is done by any supervisory level employee or a director or an officer, right? Those employees, by virtue of their position in an organization, are considered the employer for purposes of the law. And then lastly, the employer can be held liable when they know of harassment happening and they don't act to correct it. That is an entirely separate cause of action that they can be sued for. Individual supervisors, again, obviously, if you're the harassing supervisor, you can be held individually liable, but you can also be held liable for that failure to correct, right? If you know of harassment happening, but you don't do anything about it. Other employees, so we're talking rank and file, non-supervisory employees, they can't be held liable under Title VII or the Fair Employment and Housing Act. But if the harassment involves physical touching, they absolutely can be sued for things like assault and battery. They can also create liability for the employer as agents. So if the harassment is happening between two lower level employees and we know about it and don't correct it, we can be on the hook for that as well. This goes to Director Kiraly's question, who can engage in harassment? The short answer is anyone. Someone of the opposite sex, someone of the same sex, a temporary employee, a contractor, a board of directors member, customer, a vendor, a visitor, someone who comes to the workplace just to show up. Any of those people can engage in harassment that the district could be on the hook for. Now, someone like a contractor or a vendor or a customer or a director, they potentially cannot sue the district themselves, but their actions can create liability. And you're right, Director Kiraly, if you guys are not in an employment relationship with the district, you would not be able to sue as plaintiffs. The other kind of common point that employment lawyers make is that as a matter of law, you can't harass up, right? And so since you guys are at the very top level, really there's no one above you to engage in the harassing conduct that you could sue for, even if you were employees. So it would be a complicated case if there were harassment between directors about whether anyone had standing to sue.
But
You
Jennifer,
mean for,
McLaughlin.
oh, sorry, Jim.
yeah, are you saying that we are in fact not employees of the district?
I actually don't know the answer to that.
I believe we are.
Okay, got it. Some public agencies I've worked with, it can go either way. So that it really would depend on the employment relationship.
But you're right, Jennifer, at the top of the food chain, so to speak, right? We're there, but peer to peer, how
Right.
would that work if we're employees technically, even though I mean, it's possible that we may not be considered employees under the law. I mean, I don't know.
Right. I mean, there would be initially a complicated analysis about whether you're employees that have standing that can
Right.
sue. And then when you got to the specific facts, we would have to look at who has the responsibility on behalf of the employer to act in response to director level harassment, right? My gut is that the board itself would be the body that has to act. But again, I could see how that could be complicated if half
Right.
the board, for example, is involved in the particular harassing incident. You'd run into issues of quorum, of, how do we respond to this effectively? So my sense
or just trying to
messy.
ignore it.
Right. It would
Sweep it under the rug.
and attorneys' fees heavy
Right.
type of engagement, unfortunately.
Jennifer, I have
Yes.
a question. Maybe you already explained it, but it's getting back to you saying that the board members are employees of the district. Did I hear that correctly?
No, I said I didn't know
Okay,
for you guys.
okay.
Yeah, because some of us aren't getting paid, for example. So how can we be
So
employees?
that's the other question is what constitute employment? Is it, as Virginia mentioned, some getting paid and some not? Does the payment constitute employment, direct employment with the district? Because what a consultants get paid, but are they?
Right.
I mean, it's a different category. So
Yeah.
that'd be interesting.
The short answer is that there's not an easy answer at all, right? And it's dependent on a number of factors. Pay certainly is one of those factors, but isn't necessarily the sole or determinative factor, right? There's absolutely cases where the worker at issue was not paid by a company and a court still held that they were an employee. So really it's a fact intensive analysis. I'm sorry, I don't have experience with you guys, unfortunately, yet. To know whether all of you or some of you are considered employees of the district.
I just want to point, I think I will pose this question to Stephen Miller. I base my comments on, we get a W-2 form. I accumulate, Social Security credits based on, my relationship to the district. So I will ask, I think we might all benefit from knowing, in a legal sense, are we employees?
Yeah, I think Steve dropped off, but I
Jim,
really pass that question on to him
Jim?
for sure.
Yeah, Jim, just because people aren't paid doesn't necessarily mean they're not employees or fall under the employee category.
That's right. As I said, pay is not necessarily determinative in the analysis.
All right.
Okay. So quick hypothetical here. Chris and Mark are in the break room talking about the company's latest hire, Sarah. They loudly agree that she has great legs and are looking forward to seeing her around the office. Emily, another coworker, walks in just as Mark is finishing his thoughts. Who can be a potential plaintiff here? So who can sue? Who thinks Emily? Who thinks Sarah? Who thinks both? So both is the correct answer. Because Sarah is not present for the conversation, the fact that they're talking about her is enough for her to sue on. And similarly, Emily, even though they're not talking about her, the fact that she's witnessing this discussion about another woman in the workplace is enough for her potentially to sue on. Okay, let's talk about the different types of conduct that could potentially constitute harassment. Most obvious one is physical conduct, some type of inappropriate touching, massaging, hugging, blocking someone's exit to a room, standing or sitting too close to someone. Verbal conduct, also enough to constitute harassment, things like off-color jokes or slurs, sexually degrading words, graphic comments about anatomy, invasive personal questions, belittling expressions or things like honey, dear, sweetie, etc. Repeated requests for a date is one I want to specifically call out. Number of purely practical, don't have to go to law school reasons to not date people that you work with. If you absolutely have to ask someone out that you work with, you get one ask and that's it. If it's anything other than an enthusiastic yes, you're backing off. I promise no one is playing hard to get in the workplace, all right? In the movies and TV, the person that's persistent eventually gets the date. In the workplace, it gets you a nice sit down with me to talk about how temporary restraining orders work. So one ask, you're done. Nonverbal conduct, also enough on its own to potentially constitute harassment. Unwelcome gifts is sort of along the same lines as repeated requests for a date, but things like leering or staring, posters, sexual gestures, winking, sexually suggestive objects. One case I like to mention whenever I bring up nonverbal conduct in this training, it's a case I handled really early on in my career. And this involved an office environment, and the workspace was essentially like a big donut. So the supervisory employees had offices on the outer rung of the office, and then all of their assistants sat in cubicles kind of on an inner rung. And this particular gentleman in this case sat maybe 3 doors down from the office. And every day when he had to go to the bathroom, he wouldn't take that quick route to the bathroom. He'd go the long way around the whole room, and he would try to peer over the cubicle walls down the shirts of the assistants that were working there. A lawsuit was filed about it. We confronted the guy. He was mortified. He really thought no one knew what he was doing. He tried to be as inconspicuous as possible. But of course, everyone knew. And certainly when we pulled the emails of the assistants and the folks involved, that bore truth, right? We saw that there was an ongoing email thread between the assistants every single day that alerted each other that this guy was getting up for a bathroom break. So multiple times a day, they have to leave their desk, cover up, stop what they're doing to avoid being stared at by this guy. No words exchanged, no sexual content, no physical contact, and still we had a lawsuit entirely based on nonverbal conduct. Lastly, auditory, things like music or video clips, depending on the context, could potentially be considered harassment. No, you're not responsible for all of the lyrics that some artist you're listening to is saying, but maybe some workplace music is more appropriate than others.
Jennifer, could I ask a question?
Yes, absolutely.
And you may have answered it when you talked about repeated requests, but I wanted to ask about the word unwelcome. It seems unwelcome suggests that you have some basis for knowing that it would be unwelcome. And I'm trying to understand, is the first time you do something and then you get a free pass and not the second, or how does that work?
Yeah, I promise I'm not punting again, but I've got a couple slides specifically on unwelcomeness here in just a few moments. So I will address that exact question.
Thank you.
Keep in mind too, that when we're talking about different types of harassment, sexual harassment, I know that phrase calls to mind some type of sexual conduct or comments, but the phrase sexual harassment also does refer to non-sexual hostile conduct directed at someone because of their gender. So unequal targeting for discipline, for teasing, for jokes, etc., also falls under that umbrella of sexual harassment.
So Jennifer, how explicit would you mind going back to the previous slide? Just a quick question. When you say unequal treatment, like again, peer-to-peer, and we're in a public meeting, for example, what would constitute unequal treatment? And remarks that, for example, would not be made from one director to male directors, but to a female director.
Yeah, this might sound like a silly example, but you roll your eyes every time a woman speaks in a meeting, but you don't with a man, or you give the silent treatment to all of the men in the room, but you speak to all of the women in the room. So that's the kind of unequal target. Remember, it's unequal treatment because of gender. Right.
Yeah, but how do they prove that? Like if someone says, well, are you able to do the job?
Yeah, so that could be a normal question that's asked of anyone. But if someone's got a pattern of only asking that question for new female board candidates, for example, then it becomes about the pattern, right? And most harassment cases are the hostile work environment type of harassment cases. Those cases do require a pattern. So it's not.
But what if you're the second woman in 100 years to be elected to a board? Seriously, I'm just curious.
No, totally. It certainly makes it more difficult for the plaintiff and gives the defendant some excuses, right? To say there is no pattern here. So I think in that type of case, you'd probably have to show more disparate treatment. Like it couldn't just be about the one question, can you do your job? It would have to be the can you do your job plus the eye rolling, plus the silent treatment. You know what I mean? It would have to be a pattern in that way.
Okay, thanks.
Yep. Here's a quick illustration of how physical conduct can be potentially harassing.
This is Erin. Hello, Erin.
Hello, Erin. So how long are you folks in town?
3 more days, and then we're off to Paris.
We're going with the select charter group.
I love France. I was just there last year. In fact, I still have an envelope full of French francs. I'll give them to you.
Well, we can't take money.
Oh, no, it's a gift. from us.
Oh, that is so nice, Aaron. Isn't he nice? So listen, has Jerry been showing you a good time?
No, I haven't.
You know, I have a friend who works at the Metropolitan Museum of Art. How'd you like a behind-the-scenes tour?
Really? You could do that?
Easily.
It wouldn't be any trouble?
Of course not.
When?
How about right now?
I'm ready. Are you sure?
Yes.
Okay, let me get my coat.
Elaine, what do you say?
Well, I don't think so, Aaron. I have plans.
Oh. How about you, Jerry?
I'm swamped.
Sure. Could examine the artwork up close.
Maybe I'll try and catch up with you.
So the infamous close talker episode of Seinfeld, right? Great example of physical conduct that could potentially be harassing. Couple things I want to point out about this video specifically. First of all, the guy has good intentions, right? He wants to give Jerry's parents a behind the scenes tour. He wants to give them foreign currency. Do we think his good intentions matter for whether other people felt he was invading their space? No, right? They still felt like their space was invaded. At one point, Jerry's mom is all the way leaned back as he's talking to him. His intentions don't matter here. Another thing I want to point out, anyone notice how Elaine, that's the woman in the black, when he asked her if she wanted to come along, she didn't give a firm no, right? In fact, she said, I don't know, I think I have plans. So anytime you're invading someone's personal space like that, especially when there's the size disparity, it becomes a lot more difficult for someone to give a firm no. And they may appear to go along with the conduct in the moment, but that doesn't mean that they're welcoming or they're consenting to it. Last thing I want to point out, coming back to that early intervention principle, what do you guys think would happen if someone told this guy today, hey, I think you talk too close to people? What would his reaction be? Denial. Exactly, right? What do you mean?
He didn't even realize
you said
it.
that to me before. You must be too sensitive. I'm going to ignore that feedback. The longer that his problematic behavior has been allowed to continue, the harder it is to correct. Okay, I said we'd talk about two different types of harassment. We'll jump into those types of harassment now, and we'll start with quid pro quo, which is a little bit easier to recognize. Got another video illustration here.
Have you thought about where you might be summer associate?
Oh, not really. I know it's very competitive.
Well, you know what competition's really about, don't you? It's about ferocity, carnage, balancing human intelligence with animal diligence, knowing exactly what you want and how far you'll go to get it. How far will Elle go?
Are you hitting on me?
You're a beautiful girl.
So everything you just said?
I'm a man who knows what he wants.
And I'm a law student who just realized her professor is a pathetic asshole.
Too bad. I thought you were a law student who wanted to be a lawyer.
So clip from the tragically Oscars overlooked classic Legally Blonde, great example of quid pro quo harassment. And what is quid pro quo harassment? Quid pro quo is a Latin phrase that literally means this for that. And it occurs when submission to a rejection of sexual conduct is used as the basis for employment decisions. We also call it economic harassment because there's an economic consequence to that employment decision, right? You submit to the sexual advance, you get the job, you get the promotion, and you get a greater income, or you deny it and you lose your income. Really important to distinguish it from hostile work environment harassment because it imposes what's called strict liability. Strict liability is a legal concept that essentially means there are no defenses to the conduct, right? So if we have a quid pro quo harassment suit, the lawyers can quibble about what exactly were the words that he said when his hand was on her thigh, how far up her thigh was his hand. But once we all agree that his hand was on her thigh when he said, how far are you willing to go to get ahead? No defenses for the employer, okay? Really important.
Jennifer?
Supervisor's threat can be express or implied. So they don't need to say explicitly, you've got to sleep with me or I'm going to fire you, or I'm only going to give you this raise if you sleep with me. As you saw in the clip, all he did was say, how far are you willing to go to get ahead? In an annual performance review, that's a perfectly innocent and innocuous comment. But late at night on a couch with a hand on the thigh, the implication is obvious there, right? California and federal courts will apply what's called a reasonable victim standard when they're determining whether the threat was made or how the victim perceived the threat. And that reasonable victim standard comes from a famous Supreme Court case called Ellison v. Brady that essentially involved a situation of employee stalking. So it was a female employee who had a coworker who repeatedly asked her out. She said no, showed no interest at all. Eventually, she reported him to her supervisor and HR, both of whom were men, and said, you know, this guy won't leave me alone. And the company did nothing. They said, oh, I think you're overreacting. If it were me, I'd be flattered, you know, let it go. So the coworker escalated. You know, he started showing up at the bathroom every time she was there. She would go out to her car in the parking lot at the end of the day, and coincidentally, he's parked directly next to her and is at his car too. She reported him again, got no response from the company, and the guy escalated again. He started showing up at her dry cleaners in her neighborhood, even though he didn't live there. She eventually quits and says, I can't do it anymore. This is too much. And she sued. Her trial judge was a man, and the case was dismissed before it got to trial. The male judge said, you know, much like the supervisor, I think you're overreacting. If the situations were reversed, I would be flattered. She appealed. Her 3-judge appellate panel was also all men. They affirmed the same thing. We don't see anything here. We wouldn't be offended if this happened to us. She appealed to the Supreme Court. Sandra Day O'Connor wrote the opinion for the majority and essentially said, all of you are looking at it through the wrong lens. You need to look at it not as some omnipresent, all-seeing observer. You need to put yourself in the shoes of the victim. And I think the language from the court is important here. She said, we realize there's a broad range of viewpoints among women as a group, but we believe that many women share common concerns which men not necessarily share. For example, because women are disproportionately victims of rape and sexual assault, women have a stronger incentive to be concerned with sexual behavior. Women who are the victims of mild sexual harassment may understandably worry whether a harasser's conduct is merely a prelude to violent sexual assault. Men who are rarely victims of sexual assault may view sexual conduct in a vacuum without a full appreciation of the social setting or the underlying threat of violence that a woman may perceive. So ever since this case, the standard, whether at the federal level or at the state level, is you look at the conduct from the shoes of the victim. Okay, and there's some backstops to that, which we'll talk about in our next section here. All right, quick hypothetical. Bill is a new supervisor in a department with 4 other people. It's his first supervisory position. Terry, one of the employees in his unit, finds a note from Bill on her desk, which says, I would like to get to know you outside of the office. Can we go out sometime soon? Terry has no interest in seeing Bill outside of the office, says nothing to him or anyone else about the note. Bill gradually stops having personal communications with Terry. He directs assignments to her through other employees, critiques her work through written memos, and calls staff meetings when she's not around. Who thinks there's an unlawful quid pro quo here? Raise your hand. Bit of a trick question on my part. I actually don't think there's enough for a quid pro quo here. There's no this for that proposed, right? Instead, what I think you have is a case of retaliation, which, like I said, juries buy into a lot more readily. Why is that distinction important? It may sound like splitting hairs, but remember that strict liability attaches to quid pro quo claims. So anytime we can avoid saying something is quid pro quo, that's what we want to go for. We get out of that strict liability area. So the much more common type of harassment claim is hostile work environment harassment. And this type of harassment has 4 elements it has to prove: unwelcome or unwanted conduct because of a protected category that is severe or pervasive, such that a reasonable person would consider the workplace to be intimidating, hostile, or abusive. We'll cover each of these elements in turn. Unwelcome conduct, most important thing, not the same as intentional. Unwelcomeness is always determined not by what the harasser intends, by what the victim perceives. Conduct of a sexual nature, the court's going to presume that that's unwelcome. Plaintiff does not have to prove unwelcomeness when the conduct is sexual. The court's going to say no one welcomes that type of conduct. Also consider the effect of the power dynamic on whether something is truly consensual. And how I illustrate this is, you ever had a supervisor that told a bad joke? And I don't mean inappropriate or sexual or anything like that, offensive. I just mean something that's not funny. And what did you do? You probably gave them what I call the courtesy laugh, right? The, oh, and you do that because of that power dynamic, right? You do that because they're your boss. And just because you laughed along in the moment doesn't mean that you truly thought it was funny. So because of your position as directors, people may appear sometimes to go along with something that you're saying. They may not speak up in the moment. Doesn't mean that they always consider it welcome. I'm actually going to skip this video because I think we're running behind a little bit on time. But next slide. How do you tell when something is welcome or unwelcome? Anyone got any ideas?
Is it just your interpretation? I mean, this is the question I have, Jennifer. Sometimes what one person might perceive as unwelcome might not be perceived by another person, the person who's doing the action. And I'm just wondering if that could even be generational. I mean, I can see the difference in generations just with my own kids and me and my mother and me and my grandparents and me. And so the definition of unwelcome or welcome or what's a joke or what's not a joke could be generational. So how do you deal with that right now?
Yeah, I will cover that exact question when we get to that fourth bullet point, the reasonable person standard.
Thank you.
But you might tell unwelcomeness by something like a verbal response, right? Someone scoffs or says that was inappropriate, or the lack of a verbal response. You tell a joke and no one laughs, right? It's an awkward silence. Facial expression and body language, also usually a good indicator of welcome or unwelcomeness. In the Close Talker episode, remember we saw Jerry's mom fully leaned back as the guy's talking to her, good sign that she's unwelcome with respect to him invading her space. And then remember third-party witnesses too, right? In the Legally Blonde clip, there was the woman that came to the door and observed that exchange right at the wrong time. She can allege that that's unwelcome conduct directed towards women in the workplace, even though the conduct was not directed towards her. So the short answer, Director Bernstein, is that unwelcomeness, incredibly easy for a plaintiff to prove. Really, all they need to do is reliably testify that they found it unwelcome or unwanted. And welcomeness, really difficult for the defendant to approve. And a case to illustrate that, courts often say that with respect to unwelcomeness, context and optics alone are enough to prove unwelcomeness. How do things look, right? Let's use some common sense. One of my favorite cases on this point, Orlando v. Alarm One, involved the sales department of an alarm company. And this sales department would have monthly meetings. They'd meet in the conference room. And then they'd go out into the residential area surrounding the office and they'd steal their competitors' yard signs. You know, those signs people put in their yard protected by Bay Alarm or whatever. They'd steal their competitors' signs. They'd meet back in the office. They'd gather in a circle and they'd take turns spanking each other with their competitors' signs while they yelled kind of motivational salesy type things at each other. So the plaintiff in this case was a 51-year-old woman. She was only employed for 5 months. She only attended 2 of these meetings, and the majority of her coworkers were younger and were male. And she sued for hostile work environment harassment based on gender and age. And the employer defended itself by saying, well, wait a minute, you participated in these meetings. You welcomed this conduct. You both got spanked by other people and engaged in spanking yourself. How can you say that this conduct was unwelcome? And again, I think the court's language is important here. The court said spankings had a greater impact on the plaintiff simply because of her gender and age than on male employees. No middle-aged woman would want to be up there before a group of young men, turned around to show her buttocks, get spanked and called abusive names, and told it was to increase sales and motivate employees. So yes, unfortunately, the unwelcomeness element is a little bit of a hindsight thing, right? Again, someone may appear to go along in the moment with the conduct, doesn't prevent them from later saying, I truly found it unwelcome. And courts buy that, right? Again, they're saying, let's look at the context, let's use some common sense here.
Jennifer,
yes.
I brought up the question because in our organization, we used a template when we wrote our rules, I don't know, 20 years ago or whatever, and it had unwelcome touching in the office and so forth. And at the time, I felt that I didn't want to have somebody be interpreting welcome and unwelcome. So we just said no touching at all. There's just no reason for it. And we're not doing, we're setting standards of behavior. We weren't settling legal cases or anything. And so again, it just seemed in some cases there was no reason for people to be touching each other in the office. So why even permit it?
Yeah, I think the reason that most policies say unwelcome touching is because something even like a handshake is touching, right? So you don't want to have a sort of zero tolerance, no touching policy, and then you're making exceptions for things like handshakes, but you're not making exceptions for other things that are sort of, you know, up to individual people about when an exception is going to be made. So for the most part, no one's going to say a handshake is unwelcome unless it's, you know, a 30-second handshake that feels a little creepy. So that's probably why they tried to include unwelcome. Same thing with like hugging, right? Some people are perfectly fine with hugging their coworkers in the workplace, and you know that is welcome. But other people don't want to be hugged at all, and so the hugging is unwelcome for them. But I agree, it's a little bit of an ambiguous standard.
Thank you.
I'm going to skip this hypo, keep us on time track too. One thing when we're talking about unwelcome, sexual desire is irrelevant to the issue of whether something is unwelcome, okay? So you can have sexual harassment between, for example, two straight male employees. Their gender, their gender identity, their sexual orientation does not matter for purposes of whether there is sexual harassment, okay? And the law was amended to that effect about 7 years ago. Evidence of someone's sexual desire or sexual orientation irrelevant and inadmissible to establish a claim of sexual harassment. Okay, so that was our first element, unwelcome conduct. Remember, the unwelcome conduct has to be because of a protected category, and that can include any of the protected categories we went over at the start. This list here that you see on this slide is the most common types of protected categories that come up in harassment cases, with really gender and race being the most common. I think you could add up the rest of the categories and they still wouldn't be the number of gender and race cases that we see. So third element, that's severe or pervasive. Unwelcome conduct because of a protected category that is severe or pervasive. And I've got the scales up there because you should think of severity and pervasiveness as opposite ends of that scale, right? The more severe something is, the less pervasive it has to be unlawful. Something like sexual groping or touching really only has to happen once for it to be considered unlawful, but something less severe, right? The gentleman who I mentioned who took the long way around to the bathroom and peeked over the cubicles, not very severe on its own, but was pervasive, right? It happened multiple times every single day. What are some factors that courts look at when we're talking about severity and pervasiveness? It's things like whether the conduct was verbal or physical or both, whether it interferes with work, frequency, whether others joined in, whether the harassment was directed at more than one person, and then whether the harasser is a supervisor or occupies a position of authority over the victim. That one I want to talk about specifically. What that means is that conduct that you as board members engage in is always going to be interpreted more severely than your lowest level employee doing the exact same thing, right? And that's because of your position of authority. Kind of a similar principle, whether the harasser was involved in other incidents. If you've got a history of harassment complaints against you, your conduct always going to be interpreted more severely by a court than someone engaging in the exact same thing but has no history, okay? Those two things sort of combined to go back to my original point that If you've got a history of harassment complaints, makes it really difficult for you to move up a corporate ladder because it becomes inherently more risky for an employer to employ you. So last element. So we have unwelcome conduct because of a protected category that is severe or pervasive, such that a reasonable person would find the workplace to be intimidating, hostile, or abusive. And this is really goes to Director Kiraly's question. There's both subjective and objective components to this reasonable person standard. And this type of standard comes up a lot in the law. The subjective component of the standard asks, was the victim truly offended, right? And this is where your own conduct becomes relevant. If I call all of my coworkers girly or honey or sweetie, becomes much more difficult for me to say those words are offensive when directed at me, right? My own conduct is relevant. Did I truly find the conduct to be harassing or offensive? The objective side asks whether a hypothetical person who's reasonable, who matches the demographics of the victim, would that person consider the workplace to be, or the conduct to be, a hostile, intimidating, or abusive? Now, whenever I explain that standard to non-lawyers, totally get it. I always inevitably get a question, I don't get it. Who is the person, right? Well, the easiest way I have to answer that is next time you're in the grocery store, the best cross-section you're gonna get of the area that you live, the 5 people in front of you in the line, 6 people behind you, that's your 12-person jury. That's the reasonable person. It's a societal-based standard, right? It's those people deliberating, deciding, would a reasonable woman have been offended if they were in this woman's shoes? Would a reasonable elderly employee be offended if they were in this older employee's shoes? Would a reasonable Latina employee be offended if they were in this Latina's shoes? So it does vary based on age, certainly based on the area of the country. The reasonable person in the California Bay Area may differ significantly from what a Florida jury decides is the reasonable person, right? So if you think of quid pro quo as being about a single exchange, a single this for that, hostile work environment claims are about a pattern of conduct. There's got to be a pattern that together forms a hostile work environment harassment. And coming back to that early intervention principle, you never want to let that pattern develop, right? You want to intervene before the pattern develops at all and address something that does seem small in the moment, but will prevent the snowball from happening. One last thing on hostile work environment harassment, and that's romantic relationships in the workplace. As I mentioned before, number of purely practical reasons not to date your coworkers, but romantic relationships create real difficulty for instance, defining where the line is between welcome and unwelcome. Employment lawyers like to say it's never really dating in the workplace that's the problem, it's breaking up in the workplace that's the problem. Right? And actually, the majority of time, our romantic relationships come up in employment litigation usually involves cases where the plaintiff is not one of the people in the relationship. They are a third-party observer who is essentially alleging sexual favoritism, right? The common fact pattern is a consensual couple that maybe engages in a little bit too much public affection with each other in the workplace. And the lawsuit comes from a third party that says, that type of overly affectionate conduct sends the message that you have to sleep with the boss here to get ahead. I'm going to move really quickly into abusive conduct so that I can make sure I'm not keeping you guys here late. This is a relatively new law, only about 6 years old. And when this law was passed, the legislature required us to also cover it in this particular training. As far as I'm aware, there's never been a lawsuit under this particular law. The cynic in me says that that's because damages are more limited than for harassment cases. So plaintiffs' lawyers aren't as interested in bringing these types of claims. But another reason might be the legal standard that we'll cover here in just a second. So the law defines abusive conduct as conduct of an employer or employee in the workplace with malice that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interest. That reasonable person standard going to operate the same way that we saw with hostile work environment harassment. It has both objective and subjective components. Next thing I want to call out, that phrase with malice. Remember we said with harassment claims that the harasser's intent does not matter. It's irrelevant, right? Malice is what we call a legal intent element. So here, the plaintiff has to prove a specific intent by the harasser, right? They've got to prove malice. It's a pretty high bar. So that's also probably why we don't see a lot of lawsuits under this law. Last thing I want to point out in this definition, that last bolded phrase, unrelated to an employer's legitimate business interest, really important in this definition. Without that clause, this definition might be read to say you can't be negative or critical of employees at all. And that's not what the law intends or requires. Perfectly fine to give negative performance evaluations, for example, or critical feedback, because those things are related to business interests. It's when the malicious conduct has no relation to business interests that we've potentially crossed that illegal line. So what is malice? It's acting with the intent to cause injury. It's engaging in conduct that is despicable and done with the willful and knowing disregard of the rights or safety of another. Believe it or not, lawyers have a definition for despicable as well. It's conduct that is so mean, vile, base, or contemptible that it would be looked down on and despised by reasonable people. So we're talking real bottom of the barrel stuff here, right? Think Disney villain level of conduct, vile. It's not just someone who's kind of generally curmudgeon-y or surly as their mood or their disposition, or kind of abrupt with people. That's not enough. It's got to be vile, right? And there's got to be an intent to cause harm with the conduct. So since we don't have any case examples, the law itself lists a few examples of potential abusive conduct. It's repeated infliction of verbal abuse, use of derogatory remarks, physical conduct that's threatening, humiliating, or intimidating, or a gratuitous sabotage of someone's work performance. What do all these have in common? Well, there are pretty clearly not related to business interests, right? In fact, something like gratuitous sabotage is directly contrary to business interests.
Jennifer.
Don't have cases. Yes.
Before you skip, just if you could back up to just help me to understand a little bit more about the malice part of it. You said it was an intent to cause injury.
Yes.
How does that play itself out? Does it play itself out in certain behaviors or certain actions that are seeking out things that may not necessarily be truthful in nature, or is under a cover of some pretense of some sort? I mean, where does malice? I mean, how do you look at malice from?
Yeah, so malice is really hard to prove, right? If you watch like cop shows on TV, there's always some debate in an episode about, can we charge first-degree murder or second-degree murder? And they shy away from first-degree murder because they can't prove intent. Well, that's because first-degree murder requires malicious intent as well, right? And it's incredibly difficult to prove what someone intended in their mind when they took an action, right? So malice means you can't just kind of have been thoughtless or inconsiderate or even reckless, right? You have to have, when you engage in the conduct, a specific intent to cause harm by engaging in that conduct, right? So really high bar. And I'm not skipping ahead to ignore your question, but I want to get to this list. So since we don't have case examples of what malicious conduct might be under this law, what I've done over the past several years is when I do this training for staff, right, for non-supervisors, I ask them for what are examples that they think of as workplace bullying. So I'm not saying that's what's listed here definitely is illegal or constitutes workplace bullying, but it is what's on the mind of staff members. So something like, for example, falsely accusing someone of an error that you know they didn't actually make. It's one thing if, let's say there's a theft in the office, right? And the evidence seems to point to someone and you hold that person responsible, but it turns out after the fact that you were wrong. Well, you didn't have an intent to cause harm, right? You were acting based on the information that you had in front of you. On the other hand, if you were conducting the investigation, you discover a surveillance video, but no one else knows about the surveillance video, right? And the surveillance video points to someone else and you definitively, and you continue to blame some other person, not in the video, then arguably, do you have an intent to harm? I would say, yeah. Is your conduct vile? Yeah. You've got evidence that exonerates this person and you're purposely hiding it to blame someone else, right? And is that related to business interests? No. In fact, it's contrary, right? You're not holding the correct person responsible. So if something like that, I think you could prove malicious intent. But some of these examples, you know, I think it would be difficult to make the case that these are workplace bullying. Unnecessarily copying a superior on an email in an attempt to make someone look bad. That would be difficult to prove, right? That was malicious, that there was any harm intended there. Same thing with assigning undesirable work. I think it would be difficult to prove some harm there or get around the vile requirement or that it's unrelated to business interests. So your questions are completely valid, but that's exactly why we haven't seen a lot of cases under this law.
Jennifer, one quick question. I'm looking at the third bullet from the bottom, launching a campaign to oust someone.
Yeah.
We're public figures, technically under the First Amendment, for example, right? And, you know, how do you prove that? Even though if you're not in a campaign season and you're not a candidate, and let's say there's this undercurrent of whatever is happening. I mean, how, you know, is that, and we're public figures, so how does the public figure component come into this when there has been, in my opinion, a concerted effort? For example, I'm not saying I'm just thinking of a hypothetical, you know, if there's a concerted effort and you're the target of that,
yeah,
of getting someone out.
I think then that comes back to business interest, right? And remember, since malice is such a high bar and so difficult to prove to begin with, I think even someone who's leading a campaign to oust someone else, they kind of always have the fallback of saying, I think this is in the district's best interest for XYZ reasons, right?
Even though the person was the highest vote getter in an election? Yeah, I mean, I know it goes both ways, for example, right? I mean,
totally.
Okay.
But so remember, we've got that reasonable person standard, right?
Yeah.
So their conduct would have to be, again, not just mean, but vile, right? Vile, base, and contemptible. And that reasonable people would agree that their conduct was vile, base, and contemptible, right?
Okay.
There's a lot of kind of pitfalls for plaintiffs in this area and probably why we don't see the claims.
Right.
But I agree. I mean, especially your status as public figures makes it even more difficult to prove malicious intent.
Thank you.
Yep, absolutely. Okay, conduct that is not bullying, and this is written into the law. Any legitimate performance reviews or disciplinary action, including informal coaching and counseling, not going to be considered workplace bullying as a matter of law. Similarly, any non-malicious conduct, even if it's critical or negative or mean, if there's no intent to cause harm, it's not going to be unlawful. A single instance of conduct also not going to be considered unlawful unless it's severe and egregious. We don't have a court interpreting what severe and egregious means in this context, but the common wisdom is that it's probably got to involve something physical, right? You only have to punch someone in the face once for it to be considered bullying. Okay, the laws that we've been talking about, they apply to conduct in the workplace. They regulate conduct in the workplace. So that kind of begs the question, right? Where does the workplace start and stop? So quick true or false here. The things that an employee does on his or her personal time, such as breaks, lunch, or after work, cannot be considered harassment because they are not done at work. Who thinks that's true? Who thinks that's false? False is the right answer. Let's dig in a little bit more. So a bunch of hypotheticals are going to appear on the screen. Raise your hand if you think what appears is away from the workplace such that the employment laws we're talking about do not apply, okay? An office party in the office during work hours. Who thinks that's away from the workplace?
Away from the workplace?
Office party off-site, not during work hours. Who thinks that's away from the workplace? Okay. informal happy hour after work. So nothing organized, just a bunch of employees saying, hey, let's go grab a drink. Who thinks that's away from the workplace? Maybe a hand or two. Barbecue at a coworker's house with both work and non-work friends. Let's say it's on the weekend. Who thinks that's away from the workplace? Bit of a trick exercise on my part. All of these have enough connection to the workplace to probably come under the purview of the employment laws we're talking about. The key question, the standard, is there a completely private relationship unconnected to the employment? And the answer is no for these, right? And as a practical matter, you can imagine if something salacious happens at that informal happy hour or happens at that barbecue, people are still going to be talking about it in the workplace. The incident will be brought into the workplace, even if it happened outside. Think about emails before you send them. Really easy to misinterpret an email. Anyone ever told a you had to be there story? It's one of these stories you're telling your friends and you can't even get through the story. You're laughing so much. You guys are going to think this is so funny. And then you get to the end of the story and no one really laughs or no one really gets it. And you say, well, I guess you had to be there. That's what it's like to explain an email after the fact in a deposition or in a trial. Just remember, the E in email stands for evidence. By far the most common type of evidence that we see in these cases, right? And that includes Slack messages, instant messaging, text messages. The first thing we do in any litigation is pull the emails of everyone involved, not just the accused, harasser, and the victim, but any relevant witnesses, anyone who is attached to relevant events. And I get to read through all of that email. I will confess to you here this evening, it's one of my favorite parts of my job because people still do and say anything in email, even in 2021. You think you deleted it, I still get to see it. So again, I'm gonna skip this exercise here because we're running short on time. So remember, dance like no one's watching, email like it may one day be read aloud in a deposition. Okay. Let's talk about what your obligation is as supervisory employees to monitor the workplace. And when I use the phrase supervisory employees, that has a specific legal definition, okay? Even if you don't necessarily have day-to-day direct supervision obligations for any employee, by virtue of your positions, you're considered supervisory employees under the law, okay? So you wanna be alert to trouble areas. Things like joking or off-color language. Again, don't just assume because people are laughing that everyone's going along with it and everyone's welcoming it. You want to be aware of simmering tensions between employees. No, you're not required to kind of be involved in day-to-day gossip or anything like that. But if there are fault lines, you want to make sure that you're aware of those things. You want to act quickly if you suspect a problem. Remember that we have that proactive obligation under both federal and state law. Not enough for us to simply sit back and wait for harassment to occur and then address it when it does. You have to act quickly if you even suspect there's a problem. You're not waiting for someone to complain. Your goal as a supervisory employee, stop problems before they arise, that early intervention principle, and also you're kind of the front lines, the standard bearers to impress upon employees the district's commitment to providing a good working environment. Gonna skip this video, unfortunately, as well. We'll talk about complaints specifically. So quick true or false here. If there's no internal complaint about questionable or inappropriate behavior, there's no basis later for a lawsuit that alleges harassment. Who thinks that's true? Who thinks that's false? False is the correct answer, right? No requirement that an employee use internal complaint procedures before filing suit. And that's because employers are liable for harassment when they actually knew about the offending behavior or when they should have known and failed to take action, right? It's that should have known that we call constructive knowledge. So you can have actual knowledge of harassment or constructive knowledge of harassment, and that both can create liability. Remember, a formal complaint, not required under the law, right? The district does have formal complaint procedures, but just because an employee doesn't use them doesn't mean that their lawsuit is later barred. Similarly, a casual statement or a second or third hand statement is enough to trigger the district's obligation to act, right? Let's say there's some employee that you've known at the district for years and you happen to be friends. They come to you and they say, you know, this thing happened to Jennifer at this meeting. I don't think she's going to say anything because she's embarrassed about it, but I thought you should know. That's enough for you to act, even if I never complain. Similarly, your own observations. If you observe some type of harassment happening, that's enough to trigger your obligation to act, even if no one actually complains. With respect to confidentiality, if someone does come to you with a complaint of harassment, you can't promise to keep it secret, okay? You can and should say that you will keep it as confidential as possible, but you can't say you'll do nothing. Your obligation under the law to correct and prevent harassment from happening always going to override any privacy concerns. So for you as a supervisory employee, there's no such thing as off the record. Keep in mind too that I believe that the district's complaint procedure says they're allowed to go to any one of a number of people. They can go to their supervisor, they can go to HR, and my guess is that it says they can go to any of you as directors as well. So you could get an employee coming to you with a complaint that isn't necessarily someone you work with regularly. It might be someone that you just happen to be friendly with, or maybe they see you as trustworthy and reliable. If that happens, you still have an obligation to act, even if they're not, you know, your subordinate specifically, right? You're a resource for employees.
Jennifer.
So Jennifer, so who should, if one of us is feeling like that by an employee or whomever, another fellow board member, who should we go to? The chief public administrator or the attorney, or who?
I think it's still worth it for any of you to go to the top HR person, or certainly legal counsel for the district.
Jennifer.
Yes.
Your last statement that prior to the last statement, you mentioned that if someone come to us with information about harassment, should to follow up on what you just mentioned to Virginia, should we then go to the attorney, or should we take it to the fire chief or HR? How should we? Or should we just take it to our board chair at the time? How should we handle as a board member?
I think you can go to any number of those people. The board chair is a perfect person to go to. The chief is a perfect person to go to, or HR. All of those, I think, are equally available to you as they are to any other employees. I do think you can go to the lawyer too. I wouldn't go only to the lawyer, right? Especially if it's Steve we're talking about, since he's technically an outside counsel. So you can do Steve and one of those other people, but I wouldn't do only Steve. Okay, what if you are the one who's accused? I know it sounds obvious, but if you're notified that your conduct is offensive, the easiest thing to do is to be respectful and change your behavior. Again, remember when we're talking about harassment, the harasser's intent does not matter. It doesn't matter if you didn't intend to offend someone when you said something. The easiest thing to do in the workplace is not debate and just say, sure, I won't say this particular thing again. If there's an investigation, again, it sounds obvious, but you should absolutely cooperate. I can't tell you how many investigations that I've handled where we eventually exonerate the accused harasser, but there's still some disciplinary action because during the investigation, they tried to influence witnesses or something like that. You should also maintain confidentiality about the complaint. You're not going to vent to fellow board members, for example, or other employees of the district about what you think is BS or your opinion of the person who complained. You are going to maintain that complaint as confidentially as you can. All right, our last legal section here, and that's on retaliation claims. As I said at the start, these are often the most risky area of this type of law because juries buy into retaliation claims a lot more readily than they do the underlying claim of discrimination or harassment. Not everyone can identify with an experience where they were treated differently or they were harassed because of a protected category. But almost everyone can identify with an experience where they spoke up about something and were treated differently because of it, okay? So both federal and state law prohibit an employer from taking adverse employment action towards an employee who is engaged in protected activity. Protected activity includes a number of things under various employment laws, for purposes of our training, we're talking about making a good faith civil or administrative complaint related to discrimination or harassment, reporting harassment or discrimination internally at work using those internal reporting procedures, or participating in a harassment or discrimination investigation or proceeding. So it's not just victims of harassment and discrimination are protected from retaliation. Any witnesses who participate in an investigation or a lawsuit, they are also protected from retaliation. What's an adverse employment action? The short answer is just about anything. There are some obvious actions, disciplinary action, termination, demotion. There's some not so obvious actions, right? Ostracizing someone who makes the complaint, disclosing the complaint beyond who needs to know. The standard for whether something is an adverse action is simply, could it discourage someone from complaining in the future? Okay, so disclosing the complaint beyond who needs to know, for example, that's probably likely to discourage people from complaining in the future. Enough of an adverse action. A plaintiff in a retaliation claim also got to prove some connection, a relationship between the protected activity and the adverse action. Sometimes that's proven by what we call the same actor inference. So if someone complains that I harassed them, and then a week later, I'm the decision maker who decides they're going to be fired, there's an inference created that the two things are related because the same person is involved. Sometimes you've got evidence of a concurrent statement or an action, right? A harassment complaint is filed about me, about something I said in a meeting. I'm venting to my coworker. Oh God, this guy complained about what I said in the meeting. I'm just not going to invite him to the meetings anymore. It's my own words that are linking those two things, right? But most often, I'd say in more than half of cases, the only evidence of a connection between the protected activity and the adverse action is timing. Timing that looks funny. Going back to that point that we said, in these cases, context and optics alone are often enough, right? So an employee who's been employed for 5 years, raise every year, positive performance evaluations, they file a complaint, and a week later they get their first ever negative evaluation, right? For them, the timing looks funny. It looks like those two things are related. Now, it may certainly be the case that that negative review had been in the works for weeks, that it predated the complaint, but for them, the timing is close enough to potentially bring an internal complaint, okay? Questions on retaliation here? No, all right.
I have one quick one.
Yes.
Is hiring an attorney considered protected activity?
Yes, definitely. Hiring an attorney or having an attorney send a demand letter, for example, absolutely.
Jennifer, can public figures actually engage in retaliation technically, even in a public meeting, or even covert actions?
Yeah, I don't see why not. Whether they can engage in,
because it could be viewed as political. In which case, it may not necessarily be retaliation under the legal sense of the word.
Well, remember, they've still got to prove some protected activity. So the person who's saying I was retaliated against has to prove protected activity under the law, which means raising an issue of discrimination or harassment, right?
Okay, thank you.
But I agree. I mean, I think that First Amendment piece
is a big one.
A difficult case for people in your position, for sure. Okay, some closing thoughts. How do these cases play out in the real world? As I've said kind of throughout, we don't really see the really horrific fact patterns anymore. Instead, the majority of our cases involve what are called microaggressions. These are small instances of indirect, subtle, or unintentional comments or conduct against members of a marginalized group that members of the majority group don't face, right? And often they're unconscious or unintentional comments. They can come out even as seemingly positive comments or complimentary comments by people who might be well-intentioned. Those victims of microaggressions, they don't necessarily respond in the moment because the comment is by definition micro. It's something small. It feels like I don't want to make a big deal out of this. And so they let it go. But the point is, those microaggressions accumulate over time, right? They are only directed towards women or people of color, for example, or LGBT communities. They're not directed at the majority group in each of those things. So it's the accumulation of those small indignities over time that eventually kind of act as a tax on that marginalized group. Why is this important? Well, the demographics of the workplace are significantly changing. 43% of millennials are people of color. Each generation thereafter has been more diverse. Generation Z, who's entering the workplace now, is almost half Latinx, Black or Asian or multiracial. In about 20 years, we're projected to become a majority people of color nation. On the gender front, for the past 20 years, a higher percentage of women have obtained college degrees than men. Despite these changing demographics, for the most part, C-suite executives, director and officer level positions, still largely straight, white, and male. So that disparity is creating some potential for some cultural fault lines, right? Some cultural disconnect where microaggressions really can come out and thrive. What are some common gender-based microaggressions? So these are comments or conduct that's directed at women that for the most part, men don't usually face in the workplace. So being asked, for instance, when are you thinking of starting a family? A common question that women, especially in their 30s, get that really men don't get asked. And I think employers feel like, well, I'm just trying to be proactive and plan for maternity leaves, but really you don't know if, I mean, that's kind of subtly discouraging women, for example, from pursuing promotions, for instance. Certain compliments or certain words that are only used to describe women. Have you met Jennifer yet? She's a lovely girl. Just do that with a man's name. Have you met Joe yet? He's a lovely boy. We would never say that. It sounds silly when you say lovely boy, right? Jennifer can be too assertive in meetings versus I like how Joe always speaks up and stands his ground in meetings. Punishing or rewarding someone for conformity to gender-based conduct. That's not very ladylike. Again, we'd never give feedback to a man in the workplace by saying that wasn't very manly what you did there. Interrupting. Tons of workplace studies show that women are interrupted in meetings, even by other women, something like 30 to 40% more frequently than men. Taking credit for someone else's work or someone else's ideas, mansplaining, kind of the tendency for men to sometimes assume that women don't understand or don't know what they're talking about and they're sort of explaining it condescendingly, or assuming someone's position or role in a group. The example I like to give there is if you're in a meeting and there's one woman and it's mostly men, do you assume the woman's going to be the note taker, that she's going to perform the secretarial function in that meeting? Some common sexual orientation or gender identity-based microaggressions. You're transgender. Wow, you don't look like it at all. Again, I think intended to be a compliment, but most transgender people don't perceive it as such. Is that a man or a woman? This one's my favorite. Oh, you're gay. You should meet my friend. They're gay too. You never meet someone who's straight and you want to play matchmaker, right? You never, oh, you're straight. I know a great straight person I'd love to set you up with, right? We don't kind of reduce straight people to their sexuality. He or she is gay. What a waste. Again, I think intended to be a compliment. You don't sound gay or you don't look gay. Which one of you is the man or the woman in the relationship, or repeatedly using someone's non-preferred pronoun. Again, questions, comments made to LGBTQ community members that straight people don't face. Lastly, some common race-based microaggressions. You speak so well, or you're so articulate, or your English is so good. Again, I think things that are all intended to be complimentary, but most people of color do not perceive them as such, right? Instead, the perception is, despite all my professional trappings, you expected me to not speak well, right? What are you, or no, where are you really from? A follow-up question directed at diverse employees that white employees don't usually face. You don't act like a blank person, or I don't see color. I don't care if you're black, white, green, or purple. Again, cultural identity is often very central for people of color. So by saying, I don't see color, you're saying, I don't see you as a full person. And frankly, it's just not true. Everyone sees color, right? Even in unconscious bias. Oh, sorry, wrong person refers to the tendency of people to mess up or get confused the names of two people of color, even if they don't look alike, they have different job functions, they're never at work on the same days, and still you call the one Black employee the other Black employee's name regularly. Your name is so hard to pronounce, or where can I get the best cultural food item? Your blank, I love their food. Again, reducing someone's culture just to a food item, right? I'm not racist. My friend or significant other is a person of color. Never a defense to racism. Policing someone's presence. And the best illustration I have of this is kind of, if you talk to criminal defense attorneys in particular, especially Black or Latino men, almost all of them have a story of showing up to court. They're in a full suit, they've got their briefcase in their hand, they've got their court papers in their hand, and the judge still assumes that they're the defendant and not the lawyer. So assuming someone doesn't belong where they are simply because of their race, again, often despite the outward trappings that might indicate that they are in fact where they belong. And then lastly, touching someone's hair. For whatever reason, people feel more entitled to touch Black women's hair, especially without permission. Easy to say, just don't touch anyone's hair in the workplace. Even if you're a woman, don't touch another woman's hair in the workplace. But again, something that's often directed at Black women that women of other races don't really face. How do we combat these microaggressions? And remember, a lot of these, like I said, are unintentional. They're intended to be complimentary. So how can we possibly combat that? Well, you should drop the defensiveness. If someone says that you said something that's offended them, you should listen to them, right? If someone tells you, hey, when you told me that my English was so good, that was offensive, you want to listen, right? Do your own gut check. Think before you speak. Would you make this comment, or would you ask this question to someone in a majority group? Would you ask your male employee when they're thinking of starting a family? Next time you find yourself interrupting someone in a meeting, just pause for a second. Was this person a woman? Do that repeatedly and see if you notice any patterns in yourself. If someone does tell you why something's offensive and you don't understand it, this is a very popular topic in the culture these days. There's a ton of articles, podcasts, other media that explain why some of these things are problematic. So seek those out on your own, right? Don't rely on the emotional labor of the person you've just offended to also educate you on why something was offensive. And then lastly, where you can, use your own privilege to confront microaggressions when you see or hear them. So I think if we're really going to make progress in this area, it's got to be the behind closed doors group of men who correct each other on making a microaggression about women, or it's the behind closed group of straight employees, behind closed doors group of straight employees who make some derogatory comment about the LGBTQ community, and you correct in that environment, right? You use your privilege where you can, and not kind of leave it to the people that are already marginalized to do the work of correcting the behavior. All right, we are just a little bit over time here. I will stop sharing my screen here, but happy to stick around for a few other questions if anyone has any. Yes.
Jim, I wanted to ask about how far an employer can go to actually correct a situation. So
I'm sorry, I missed the last part of that question.
How far can an employer go to correct a situation? So if, for example, two people are dating in an office and it's bothering other people, can an employer, I mean, probably can't fire one of them, but can you relocate them, put them in a different office to avoid that? And then, I mean, the risk is you get sued by one of them for violating their privacy, their right of privacy or something.
Yeah. So the short answer is the employer can do a lot, right? And I want to caveat that by saying, I'm going to assume we're talking about non-union employees here. I think if union employees are at issue, there's much more restrictions on what the employer can and can't do, okay? So assuming a non-union employee, usually what we do is we like to have a written non-fraternization policy in your handbook. So we kind of start before there's even a problem. And then in most cases, you end up transferring the superior and not the subordinate, right? And that's because of the legal risks that are at issue there. Now, that concern could shift based on the particular facts of the case, right? Let's say you've never had a female supervisor in a department and you finally get one and she engages in a consensual relationship with a subordinate, then I don't know that you automatically follow the rule of transferring the subordinate. You probably do, but we want to pause. There's no one size fits all rule there. But the employer absolutely has the discretion, especially if you've already got that non-fraternization policy in place, to transfer someone else. Again, I agree. I wouldn't recommend firing anyone, but you certainly can transfer someone to a different office location, a different supervisor, for example. We almost always want to change the reporting relationship at a bare minimum.
Jennifer, a question about our role as directors. If there was a alleged harassing or discriminating behavior within the ranks of the department, and it had been handled by, or say it had even been ignored and gotten all the way up to the chief level, would it be aggravating if we did not know about it? So it's being handled below, within the organization, but let's say it wasn't handled properly. Would there be greater liability if we as board members weren't even aware of the incident or an investigation?
So I think the answer depends on the level of the employees at issue, right? If the chief is accused of harassment or discrimination, the board should absolutely be involved, and it would be pretty egregious if you weren't, right? Remember, you've got that proactive obligation. On the other hand, if it's your lowest paid, bottom of the totem pole employee in the district, and it's a peer-to-peer harassment, I don't necessarily think the board needs to be involved in that situation. And in fact, you're right, in that situation, it might be better if you don't know. And the reason is a little bit technical. So punitive damage, I guess actually I take that back. Punitive damages aren't available against public agencies. So I would still say that in that situation, on a very, very lower level employee, I think it's better if the board's not involved and that you leave that to your day-to-day staff to handle. That changes, like I said, the higher you go up the ladder.
So let's say it's a manager and a supervisor. If does that change your response?
It probably still depends on the facts of the case, right? If it's an internal complaint that's based on maybe 2 or 3 of those like microaggression type comments, and it festers, I'm not so worried about the board knowing about it. If it's a sexual groping case, I think the board absolutely needs to know about it. Or if it's one of those quid pro quo cases, I think the board needs to know about it. So still going to be kind of fact dependent. So the higher up you go, the more severe the allegations, I think the greater the board's obligation to get involved. But otherwise, I would prefer that you leave. I mean, that's why you've got an HR staff, right? That's why you've got an administrative staff. I would prefer that you guys stay out of it, especially if it's at the internal complaint stage. If there's a demand letter that's sent by a lawyer, for example, pre-litigation, absolutely. Then I think the board gets involved then.
Thank you.
Yep. Yes.
I have another question. It's hypothetical, but let's take our district, for example. Somebody is having an out-of-town wedding. It's likely to have lots of alcohol. 20 people are invited. 18 of them are men, married and single, and 2 of them are single women. And I were to hear about that, and it turns out that one of the single women, let's just say hypothetically, was the HR director or HR manager. What do you do about something like that?
Yeah, I mean, that's a tough one, right? Remember, for the standard of whether the harassment happened away from the workplace, is there a private relationship unconnected to the employment? Well, there, I think you're splitting the baby, right? The relationship is not private, but there is arguably an out-of-town wedding is unconnected to the employment. So there, I think you're really going to see it dependent on the facts of the case. And most often what happens in those types of cases is, let's say that some harassment happens between two employees that are both at the wedding. The fact that it happened at the wedding usually is not enough for legal liability to attach to the district. But let's say the person who felt harassed does report it at work. HR tells them, you know, it was at a wedding, nothing happened in the workplace, we can't really do anything. That's probably the right response. But if something then happens at work, you're immediately on the hook, right? You knew of this potential simmering tension between these two employees. You know, I think the question arises, should you have done more after you were on notice, even though the conduct happened outside of work? Should you have done more to prevent the further harassment from happening at work, right? So let's say the two people involved, they share a small office, right? And you get this complaint about something that happened at a wedding. You know, you can't necessarily discipline someone for what happened at the wedding, but query whether you should examine reshuffling their offices and not requiring them to work together in this small enclosed space, right? So you're thinking about, again, that proactive obligation. You're not on the hook for what happened at the wedding. You are on the hook for knowing about what happened at the wedding and the question of whether you took reasonable steps to prevent further harassment from happening.
But what about preemptively asking some or all of them not to attend together? You have the right to do that.
I don't know that you've got a right to do that. There's a separate labor code provision in California that prohibits an employer from taking disciplinary action against employees for engaging in lawful off-duty conduct. And certainly attending a wedding of a coworker is lawful off-duty conduct. So, you know, I don't think you can say don't go. But I think, you know, it's fair to say, hey, if there's going to be alcohol involved, just keep in mind, all of you have to come back to work together on Monday. I think saying something like that is totally fine.
Thank you.
Mm-hmm. All right. Anyone else?
Jennifer.
Thank you guys so much for staying so. Oh, I'm sorry.
Oh, no. If I think of anything, can I contact you?
Yes, absolutely.
Okay. And I agree with you about Legally Blonde, by the way, one of my favorites.
It's a great one. Well, thank you guys for staying so late.
Thank you.
And for participating throughout the session. Really makes it easier to do on my part. I will have Steve get back to you on that employee question as well.
This was very helpful. Thank you very much.
Thank you,
Yes,
Jennifer.
thank you all.
Thanks.
Have a good
Thank
evening.
you. You too.
Good night all.
Bye. Bye, Jim. We need to adjourn, right?
Yes. Oh,
I'll make a motion to adjourn.
Your second?
I'll second.
Thanks, Chuck.
would you like me to do roll call now?
Please.
Thank you. Director Crawley,
Aye.
Director Jones,
Aye.
Director Solano,
Aye.
Director Bernstein,
Aye.
Director McLaughlin.
Aye.
Thank you.
Thank you, Jim, for setting this up. And Michelle, thanks.
Yeah, no problem. Have a great night, everyone.
Good
You
night.
too.
Good night.
Bye.